Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Derek Jackson, and today's episode is titled, Is the EU Position Now Clear? The European Commission's Draft Guidelines on Exclusionary Abuses of Dominance. The European Commission has, in August 2024, published draft guidelines on the prohibition on exclusionary abuses of dominance in Article 102 of the Treaty on the Functioning of the European Union. This was a long-anticipated update on a 2008 guidance paper, and it aims to capture changes in the case law and practice during that period. Today, we will discuss the new guidance, the analytical framework it applies, and the implications going forward for lawyers and for businesses. My co-host today is Matthew Hall. Hello, Matthew.
Hi, Derek.
And who is our guest today?
Our guest today is Rona Bar-Isaac. Rona is a partner and head of competition at law firm Addleshaw Goddard, based in London. She specializes in UK and EU competition and merger control law, including antitrust litigation. Hello, Rona, and welcome to the show.
Hi, Matthew. Hi, Derek.
The guidelines that Derek introduced are important for various reasons, including that they are the Commission's first on the abuse of dominance. It's important to note that they only deal with exclusionary abuses, so those aimed at reducing competitors' ability or incentive to exercise a competitive constraint on the dominant company. So we're looking at issues such as predatory pricing, margin squeeze, exclusive dealing, refusal to supply. We're not talking about, and they do not cover, exploitative abuses. They will be important also at the national level in the EU, because the Commission's interpretation of Article 102, so the EU-wide provision, also impacts the enforcement of similar national laws. Of course, they're important to companies and advisors as an aid to their own self-assessment of practices. The Commission emphasizes that an effects-based approach to Article 102 is, quote, front and center in the draft, which continues the theme of its 2008 guidance document. In fact, the Commission terms this a workable effects-based approach. So that remains to be seen, and maybe we'll be discussing that today. Rona, the draft is some 50 pages long, divided into various sections, starting with an analysis of how to assess the basic issue of whether a company is dominant and therefore potentially subject to these guidelines when introduced formally. Looking at the dominant section to start with, what did you notice in that section of interest?
So, to a large extent, there's nothing surprising in it. It's reflective of what you would expect. I think there's probably 2 points to pick out. One, by comparison to the European Commission's previous enforcement guidance, it does include a material new section on collective dominance. I guess it's an interesting question why it's there. To the extent that these are guidance rather than enforcement priorities, and this is a full codification of the relevant law on exclusionary abuses, you might say that's the only reason it's there. There is a concept of collective dominance, i.e. dominance that is attributable to a group of actors working together. But the case law on this now is very old and not much used. So I suppose the debate is this benign and a codification exercise, which seems like it might be the case, or is it indicative of an intent to apply those concepts? And I suppose the only thread that caught my eye in that sense was reference to interlocking directorships and some of those concepts that have been discussed, which might suggest that it's there for a reason. I suppose the other element, which perhaps is just a case of causing confusion, is at what point can you presume dominance? So there's a presumption in EU law of dominance that shares over 50%. The case law suggests that below 40% dominance is unlikely. There's a reference, though, in the guidance, de minimis threshold of 10% and nothing in between. I'm not sure much is meant by that, but it does have the capacity to make people concerned about what happens between 50 and 10. So that might be an area that would merit from some clarification.
As you say, that's a bit strange because the 2008 guidance paper expressly indicated that dominance is unlikely below 40%.
Well, indeed.
And 10% is a rather low figure for dominance, to say the least. So that is an interesting situation, and maybe it'll be adjusted and made clearer in final guidelines. That remains to be seen. So that's the question of dominance, the basic issue for a company when looking at this paper or that looking at these draft guidelines. Then the next section of the draft guidelines moves into the substance. And here the Commission in Section 3 or expressly sets out a two-step test for analyzing the issue of whether behavior or activity is abusive. So this is obviously, as Derek mentioned, based on the case law, as they've said. So could you just take us through that two-stage test and how it's been arrived at?
Sure. So concept of abusive dominance is special responsibility not to engage in conduct that impairs effective competition. So far, it's just a reflection of the law. The two stages that they then set out to assess that are two concepts. One, competition on the merits. So you have to establish whether to be an exclusionary use, you need to establish whether conduct departs from competition on the merits, stage one. And stage two, whether the conduct is capable of having exclusionary effect. Now, at the outset, both of these are concepts that exist in the existing UK case law. They're both there. They're both referred to in the cases. I think it is fair to say that putting competition on the merits front and center as the primary and first element of the test is a departure perhaps from certainly the previous enforcement guidelines and certainly some strands within the case law as it exists. And the question is, well, what is this concept of competition on the merits? What's its content? And to what extent is it different from this question of capable of having exclusionary effects? Because exclusionary effects is something that, there is case law in the context of particular abuses. There's the concept of, well, is this capable of excluding because an as efficient competitor can't compete? So you've seen that explained in pricing cases. You've seen that explained in foreclosure cases. So that is where the previous focus had been. It's clearly evidentially challenging. And then there's this other concept, competition merits, which has always been there, but its content is much less well understood, I would say. And, you could say it can mean what you want it to mean.
Yeah, it's, as you say, you could say, and some commentators have said, that these are really two sides of the same coin. And I think it's interesting to look at paragraph 52 of the draft guidelines, which kind of explain it, where they say that they just make the point that a dominant undertaking may have to refrain from engaging in certain practices unobjectionable for undertakings that do not hold a dominant position.
And that's the issue. Is it the same thing, in which case why have it? Or is it something different, in which case what is it? And I suppose it's probably worth rehearsing a little bit what it could be and is not said to be. So you could look at competition and the merits and say, well, is it something that it implies some measure of intent? If you're not competing on the merits, are you trying to use some means that are not designed to be use of your natural competitive advantages and capacities? Now, that's not what's being said. Is it a concept of market norms? That's explicitly not what it is, because a number of these practices are used by firms who are not dominant, and they're and actually also, if you fixate on market norms, you risk undermining innovation. How do norms change? How does that evolve? So it's not that. Is it some concept of fairness and equality of opportunity? But that doesn't seem right either. So if you sort of work through, well, what are the possibilities for what might it be that isn't about capable of exclusion in an economic sense? Well, what does it mean? What are you left with?
As you say, it certainly can be activities which are market norms, and that's expressly what it says in paragraph 52. But I think helpfully the Commission does go on to try to give some guidance on how we identify the issue of what is competition on the merits. And then this is later in section 3, in particular section 3.2.2, where the Commission says, look, this is what we mean by competition on the merits, and it divides it into 3 broad categories to help the analysis. So can you take us through what those 3 broad categories are?
I guess they're not analytically a thing. It's self-referential. So you start with conduct fulfilling the requirements of a specific legal test that is deemed as falling outside competition on the merits. Essentially what this is, look, we've been around this rodeo before. We have certain kinds of conduct that we know. We've tested them in the courts, in enforcement activity, and we've identified them through that process as not competition on the merits. So that's not a principled position. We've learned by experience that these things may not be competition on the merits. So that's things like exclusive dealing, tying and bundling, refusal to supply, predatory pricing, margin space. So that's one component. The other component is conduct that holds no economic interest for a dominant undertaking, except that of restricting competition, so-called naked restrictions. So there is no rational explanation for why you are doing what you're doing, other than an inference that you are seeking to exclude competition. That comes quite close to saying, look, this is intent, or it's so obvious the only rational explanation is exclusion. Fine. And then the third element, as regards the other conduct, it needs to be shown the conduct departs from competition on the merits based on specific circumstances of the case. So they then list a number of, so again, this is case-by-case assessment, and then they list a number of factors. So the factors are prevents consumers from exercising choice based on the merits of the product, whether the dominant undertaking provides misleading information that make it more difficult for competitors to enter the market, whether the undertaking violates rules in other areas of law to affect the parameters of competition, such as price, choice, quality, whether the conduct consists of or enables biased or discriminatory treatment that favors itself over competitors, whether it changes its prior behavior in a way that's abnormal or unreasonable in the light of market circumstances, etc., whether a hypothetical competitor as efficient would be unable to adopt the same conduct. So it's a number of specific behaviors, again, drawn from the case law. There's nothing principled about their codification. They're a useful classification of things that are out there. They all have some level of exclusionary effect capability embedded in them. You're saying prevents exercise of choice. So arguably competitors' ability to put their products in front of consumers. Those kinds. So that there is an element, there's an element of circularity about this, or interrelationship, interdependence on this, which is potentially confusing.
Exactly. There is circularity. As you say, you can maybe leave aside the naked restrictions, which are maybe easy to deal with in a very limited group. But the first category, where there are specific tests, which really look at, are these exclusionary activities like predatory pricing, and the category you're just going through, again, they're self-referential. And I think you could say that our paragraph 57 in this section also makes that clear. It's looking at a pricing above average total costs, or in other words, a type of predatory pricing. And then it says you can determine if this is competition on the merits by looking at some of the factual elements, i.e., is it exclusionary? So
exactly. And I suppose for me, maybe this is to do with understanding what needs to be done to show exclusion as an unduly high bar. So if you say you have to show exclusion, or you have to show, a likelihood of exclusionary effect, you can see that evidentially that's a relatively high bar. And you can see that that is most effective in cases where competition is static. You can get the evidence, you can, at least in principle, and you can do that. And to some extent, going wider, it's not explicit, but I wonder whether it's about markets where competition is dynamic, there's a bit of innovation, trying to show exclusion, likelihood of exclusion might be evidentially trickier. Okay, I know that the guidance talks about capable of exclusion rather than anything else, and that word could carry some of that work. So I wonder whether that's the context in which this struggle is going on, where you're thinking about markets that are dynamically competitive rather than static markets.
Yeah, absolutely. Now, so that's the first section of part of the test, the two-step test. Does it amount to competition on the merits? And then I think, as we've been discussing, there's quite a strong overlap here. But the second part of the test is there a capability to produce exclusionary effects? And then this is expressly dealt with in section 3.3.1, again with 3 categories. Bearing in mind there is a strong overlap here with the merits analysis. Can you just take us through how that has been set out by the Commission?
In a way, it's a recut of the similar sorts of case law, but what it's trying here to do is to say, look, there are several buckets in which we can categorize conduct to say these are the ones that are very likely to be abusive, and therefore, because the nature of the behavior is such that it is highly likely to have exclusionary effect. There is another bucket that says, look, in these circumstances, for these certain kinds of conduct, you could presume that there are likely to be exclusionary effects, but that presumption is rebuttable by evidence. And then there's a third category which says, all right, well, we just have to weigh it up and see. And for which, you need to demonstrate a capability to produce anti-competitive effects. So there are, and there's nothing fundamentally wrong with that conceptually. We're very familiar with it from the verticals framework. We're very familiar with it from, chapter 1 context. If the economics is strong enough that this kind of conduct, all things being equal, is highly likely to lead to bad things, and you feel that's a safe presumption and there's consensus around that, I don't think there's anything wrong with the presumption. I think in this context, the question is, how hard-edged can that presumption be? How much consensus really is there around the evidence for these behaviors, particularly where you're still dancing around what you really mean by exclusionary effects? And
just to put some flesh on those bones, so we say there are these hard presumptions in certain cases. For example, destroying infrastructure used by a competitor, unusual situation, probably.
I think there is a case on that. It has happened. So.
It has happened. There's then the soft presumptions, which are much more common cases, which are therefore rebuttable and justifiable with efficiencies. So we're looking at predatory pricing, exclusive supply and purchasing, and then the general category. Then the general category.
One question on these coming from the U.S. perspective, are these types of presumptions that Matthew just described, is that something that has been present in the case law up to this point?
There is. In specific conduct, in specific cases for specific categories of abuse. So there are presumptions around how do you assess a margin squeeze? There are presumptions around how do you assess rebates in the case law? They have been hotly contested. The case law swung back and forth on some of these. So it's, I suppose that goes to my point. How hard-edged can these presumptions be where the underlying economics is not completely settled? And some of those are better settled than others. But yes, they're being drawn from the case law. I guess they're given more edge in the context of this codification.
The commission, as we said at the outset, is trying to put in place a so-called workable effects-based approach. So maybe they're trying to kind of balance a number of factors and making it actually usable by companies and advisors. So those are the sections dealing with, does it amount to competition on the merits, and the question of capability to produce exclusionary effects, or at least the burden and the presumptions on that issue. Then there's some sections in the latter part of 3.3, Rona, which look at various other issues when proving the capability of producing exclusionary effects. Really, this goes through and codifies and just sets out points from the case law. But did you identify anything particularly useful in any of those sections? So this would be 332 on the substantive standard, 333 on relevant elements to look at, and 334 on irrelevant elements to look at, largely focused on where you're needing to analyze it as opposed to when there's a presumption, I guess.
Yeah, I guess that's right. So what would you draw out? It's largely, as you say, from the case law. So what are they saying? They're saying conduct has to be at least capable of producing anti-competitive effects. So it's important to say, doesn't have to actually produce, doesn't have to be intended to produce, but it does have to be at least capable of producing. So you have to have a coherent, credible theory by which those anti-competitive effects might result. That's helpful. Okay, so it's fact-based assessment. It is market context, so that's all relevant. I mean, what else do I draw out? Then they say elements that might be relevant. It has to take account of all the facts and circumstances. So the challenge here is there are lots of exceptional cases. So, to put it flippantly, all foreclosure, like Anna Karenina, all happy families are the same. All unhappy families are uniquely unhappy in their own way. All foreclosure cases are uniquely foreclosing in their own way. And I guess that is what some of this characterization is reflecting. And what they're trying to say is, we're not going to shut this down too tightly. That's when you get to the end part, things that will not be determinative. So you don't have to prove actual harm. You don't have to prove profitability of the conduct. You don't even have to prove direct consumer harm. You don't have to prove that competitors are affected by it. You don't have to prove that there's upside for you. There's no de minimis threshold. So I guess it's all of that. They're saying you need to look at all the factors all together. You need to look at it in the context of the market. You need to take all of the things that you would expect. What does it do to entry or expansion? What does it do to innovation? What does it do to customer benefit? But there's no easy get out. And that's probably right.
I think that's right. I mean, some key points, indeed, as you say, you don't need to show actual exclusionary effects. You don't need to show direct consumer harm, although the Commission would need to show that the effects are attributable to the conduct. And also,
but it doesn't have to arise from your dominance.
Right. It does. Exactly. It does not need to be enabled by the dominant position. And I think maybe a final point, of course, there does need to be a counterfactual analysis. So you do need to compare in the absence of the activity against what was the result of it.
I think that's right. But in the same way as that's been a struggle in mergers in dynamic forward-looking markets, that in itself is an interesting exercise.
Right. And they probably have quite a lot of discretion on that issue. Okay, so that's looking at, do we have an abuse? Do we have competition on or off the merits? Do we find exclusionary effects to the sufficient standard? Then the Commission in Section 4 looks at certain categories of specific abuse, which is pretty long, and I don't think
Need
wanna-
detain us.
need to detain us, really. And then in section 5, there's quite a useful, although relatively short section on the so-called defenses. So we have 2 defenses. And so could you just discuss whether you think they're useful and, what they are?
I think they are useful. I think people sometimes by shorthand talk about, efficiency defense and think of it relatively similar to a sort of 101 foreclosure context. I think there are actually 2 buckets, and this is made explicit here. There are justifications where there is conduct that is objectively necessary for some reason. And that reason might be because you have to achieve a certain aim, because it comes from legitimate commercial considerations about case law. If you're refusing supply to somebody because they can't pay you, that's not an economic justification as such, but it is an objective justification for refusing to supply somebody. There are, objective justifications around compliance with legal obligations, although I see that's been framed very narrowly here to say, look, you're not the arbiter of that, et cetera, et cetera, et cetera. So there's that category of objective justification. And then there are objective justifications that are genuinely about efficiency, where you say, conduct is problematic, but comparable to the verticals framework. There are nevertheless benefits from this conduct, efficiencies that come about that counterbalance or outweigh the negative effects of the conduct on competition. So both are available to you. I think because of those 2 categories of defense, they're probably more usable and have been more usable historically than has been the case in the kind of verticals context, 101 context. And the codification is helpful. But I do note that some of those are perhaps narrower than you might ordinarily have jumped to.
Yeah, as you say, I think it is useful to see that written out, although in pretty short order. Both the efficiency defense and the objective necessity defense, the first one you were discussing there. Okay, so that's the guidelines. Shortly after the draft guidelines were published, so on 10 September 2024, a massive judgment of the European Court of Justice was handed down in the Google Shopping case. That Google Shopping case is referred to many times at the general court level in the guidelines. So this was the appeal of that general court judgment. What do you think about the Google Shopping ECJ judgment and how it aligns with these guidelines or otherwise?
I mean, we're all still absorbing it. It's pretty new on date of recording this, but it's quite a nuanced analysis. So I suppose 2 things. One is big battle fought in this judgment, which is what presumptions can we take advantage of? So battle lines drawn. Is this a refusal to supply case that falls within the Oscar Bonner category? So this is a famous case that sets a very high bar for saying that refusal to supply is an abuse. That's been chipped away at. And what you get is you get debates on classification of conduct to take advantage of certain presumptions or non-presumptions. So what you see is new presumptions being adopted depending on how you classify the conduct. So it does make you wonder whether the classifications in the guidance become a battleground in themselves or a moving feast in circumstances where actually characterization of the conduct is not completely straightforward. Is it discrimination or is it refusal to supply? Is it a closed category of always refusal to supply, or is there a subset of refusal to supply that meets presumptions or not? So I think that's interesting in and of itself. It's interesting that to the extent competition on the merits is deployed in the judgment, it is actually applied in a somewhat old-fashioned sense of a defense by the allegedly dominant company. So what's the flashpoint of the judgment? It's Google saying, look, what we are doing is normal competition. We are building a product. with a number of different aspects. It's what everybody does. It's positive for consumers. It is normal competition and therefore competition on the merits. So it's not, so the characterization is almost a matter of defense rather than is this an exclusionary abuse? So that tension is, so that concept has always been there. The question is, what order you put it in? Is it something that is right from the off at the beginning? This is the thing that determines whether it's an abuse. Or is it a sweep up at the end that says, all right, well, we've looked at the effects and the kind of thing this is, but is it nevertheless competition on the merits? So there is a question of order here.
Absolutely. And I think we should have probably said at the outset, to make it clear for those who don't know the case well, that this is essentially Google as the dominant provider of a search activity in the EU, favoring its own comparison shopping service, Google Shopping, in search results. As you said, Rona, Google's making a strong argument that this should have been analyzed under the refusal to supply case law, whereas the Commission and ultimately the ECJ agreed that this was a self-preferencing case, and therefore treated in a different way. Although, but I think helpfully the judgment expressly states that self-preferencing is not, in fact, always isn't always off the merits.
I think that's right. So I think that's right, and I don't think that's surprising. I mean, maybe the way things have gone, sometimes it looks surprising. I don't think that's surprising, but it is it's a different standard in terms of the presumptions you start with compared to refusal to supply, hence the battle. But yes, the judgment explicitly says if it's self-preferencing, that doesn't mean it's always a problem. It means it's sometimes a problem. And then it says it has to be justified on the basis of the full context, on the basis of the evidence, and in the context of this and in the context of the evidence that we had before us, this particular instance of self-preferencing was a problem. It won't always be. So, that's helpful. I think just in terms of this question of competition on the merits, I'd also highlight 164 in the judgment. So this is, again, a relatively old-fashioned formulation, again, of competition on the merits. So it says, it's not the purpose of 102 to prevent an undertaking from acquiring on its own merits a dominant position in the market. So what it's saying, you're allowed to compete, you just need to compete appropriately. And it explicitly says, on the contrary, competition on the merits may, by definition, lead to the departure from the market or marginalization of competitors which are less efficient and so less attractive. So you're back to the question of, we're looking at effect, we're looking at foreclosure, we're looking at exclusion of competitors from the market, and we are asking ourselves, is that exclusion something that ultimately harms consumers by denying something that they would otherwise choose to buy because it was attractive and cost effective, versus what's offered by the dominant firm? If you're back to that interlinking,
as you say, it is muddied, I think, in other places in the judgment as well. The final points on this, and again, I think we mentioned this earlier, but also caught my eye somewhat, was the leeway afforded to the Commission in relation to the counterfactual, looking at paragraphs 223 onwards, where it seems that the Commission has been given pretty significant leeway on that issue.
Yeah, I think that's right. And I guess the only thing before I move on as well, in terms of abuse and capable of effect, it does say explicitly it could be an abuse not only where it might have an effect or proven to have an actual or potential effect, it also brings in objects as it can be an abuse where it even has the object of impeding potentially competing undertakings. So I just note that.
I think we're going to shift gears as we close the show here and just touch on a little bit of the personal or human interest side, as we like to do at the end of our shows. So I'm gonna kick this off. Please, could you tell us something interesting about yourself or unusual about yourself that we wouldn't know if we only knew you in your professional capacity?
I have become an enthusiast for observing total eclipses of the sun. So I've seen 3, and purely for the astronomical impact. It's an experience of it as a natural phenomenon, and it started to become the organizing principle of my vacations. Last one, just before spring meeting, I managed to catch it in Toronto. I am looking ahead to eclipses in 2026 and 2027. I found it's quite a useful way to decide where you're going to go next.
Well, that's really interesting. Where else have you traveled to go catch these eclipses?
So I've seen, I've not. So the first one I saw was in France many years ago. We slept in a car because there was no accommodation. It's the only way to get to see it. We came to the US for the big American ones. We saw it in the Grand Tetons, which was pretty spectacular. It was too tempting not to stop in Toronto on the way to spring meeting. Next one, I think, is visible. Choice of Iceland or Spain. I think I'm leaning Spain for better skies. And then Egypt in 2027. That's my tip. So it's silly, but it's fun.
That's rather amazing. I remember seeing one in Brussels. We left a meeting. We were discussing a merger with the client to stand outside.
Yeah, that's the same one. That was the 90s one.
Yeah,
where I slept in the car.
Right.
Now I think we're gonna do a segment of our show that we like to call the Curious Hat.
And now it's time for the Curious Hat.
And Rona, the Curious Hat is a segment where we draw a question from a now virtual hat, from a series of random questions to ask you and get just a little more flavor of your personality. So I've selected today's question, which is, what is your favorite sport and why?
That's an interesting question. I am no athlete personally, I will admit to that. So this is mostly about spectator sports. And my choices there are quite eclectic. I've recently enjoyed going to see women's football. I have a daughter who's enthusiastic about watching it and following it. So football in the soccer European sense, not the American sense. I wasn't a soccer fan, but I acquired an interest through various cases I did. It's quite fun being a distant interested observer in that context, but increasingly I've enjoyed it. And I say so, particularly the women's part of the game, which certainly here has become more participatory and, more exciting to watch.
Do you have a favorite club?
I live on the Tottenham Arsenal fault line. So I will get this horribly wrong. We're an Arsenal household by and large. My husband is from Manchester and he assiduously refuses to have anything to do with either of the big Manchester clubs. So his club is Stockport County, which is a sort of lower league club. And he used to make me go watch them live. Last time I went, they were on a big unbeaten streak. And I was, he promised me they would win. He promised me there would be stadium seating when they were playing in London. Neither proved to be true. So I'm now banned from their games.
Yeah, I understand the, the sort of geographic fault lines for football club rivalries in the UK can be quite intense. Well, Rona, thank you very much. This was a really fascinating topic and a really informative show. And to all our listeners, thank you for listening to this episode of Our Curious Amalgam, and we look forward to speaking to you again.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.